Hello friends, welcome you all to the Citizen Justice Forum video channel. Our mission is to empower Indian citizens by sharing knowledge about the fundamental rights that is given to them by Constitution of India. If you are watching this video for the first time, click the subscribe button. Select also that you get the notification whenever we are online or upload a new video and you don't miss out on any of our videos. नमस्कार सत श्री अकाल दोस्तों, आप सभी का स्वागत है सिटीजन जस्टिस फोरम के इस वीडियो चैनल पर। हमारा मिशन है भारतीय नागरिकों को उनके अधिकारों के बारे में जागरूक करना जो उनको भारतीय संविधान ने दिए हैं। आप इस वीडियो को पहली बार देख रहे हो तो सब्सक्राइब को क्लिक करके सिलेक्ट ऑल कीजिए ताकि जब भी हम नए वीडियो बनाते हैं या अपलोड करते हैं या ऑनलाइन आते हैं तो आपको उसकी जानकारियां मिलती रहेगी। आज की जो टॉपिक है लेबर लॉज इन इंडिया, और बहुत ही बेहतरीन स्पीकर है जिसका इंट्रोडक्शन हमारे आमिर खान, इसका रियल नेम है मोहम्मद अफजल, वो आपको इंट्रोड्यूस करेंगे और आगे का प्रोग्राम मोहम्मद अफजल।
एनी मैथ्यू है, शी इज अ प्रैक्टिसिंग लॉयर और उनकी एरिया ऑफ वर्क इज लेबर लॉ, मैट्रिमोनियल इश्यूज, डोमेस्टिक वायलेंस, क्रूरटी टू एनिमल्स एंड रिलेटेड मैटर्स। वो काफी करीबन 2 डिकेड से ज्यादा इस विषय पे काम कर रही हैं एंड शी इज प्रैक्टिसिंग इन ऑल दी रेलेवेंट कोर्ट्स। एंड विदाउट वेस्टिंग एनी फर्दर टाइम आई वुड request Mini Matthew to take over.
Thank you. Friends, it's interesting that we are having this topic today, which is 27th April. We are close to May Day, that is 1st of May, which is actually International Labour Day. The reason why this is so important to understand is that the origins of May Day lies in the struggle for an 8-hour work week. What we take today for granted came from decades of struggle, and which was not just happened in India but globally. So the origins not just of May Day, which we celebrate with a holiday, but also the International Women's Day, which is celebrated on March 8th, its roots in the struggle in labor rights. Basically, the historically it came from mass movements of workers who struggled for some regulation in their hours of work, conditions of work, wages, etc. As removed from, and to get some sort of justice and dignity, which would move them away from the sweatshop conditions. In India, it's very, very important for us to understand very briefly from where our labor legislations came. And for us, it is the origins lie in our freedom struggle. So many of our freedom struggle leaders were also the initiators of unions and workers' collectives. For example, people like Lala Lajpat Rai, etc. And very interestingly, all legislations, if you will see, they are coming from that period. Today, when we talk about labor legislations, in use, I would say there would be at least 30 of them, but on paper there are at least 59 to 60. So when I say that, it means that it takes into consideration the wide variety of workers, the working workplaces. So you have BD workers, you have plantation workers, you have construction workers, you have people working on the docks, you have people working in the offices, you have people working in factories. All of these are very, very interesting, very, very challenging. So how do you create a path where all of these rights which are available can be made, can be fruitified? So before just going into the legislations, let me tell you one of the principles one of the principles of labor law is what is called collective bargaining. And what is the meaning of collective bargaining? It means that today, in practice, if you are an individual worker or an employee, how will you deal with a big corporation? How will you deal with an employer? How do you ask for your wages? How do you ask for your rights? Simply because it's an unequal situation. So you're basically, this is a relationship of unequals. So what collective bargaining does is that it creates a system where there is an employer, there is an employee, there is also the government. Okay, so in this, there is a balance which is created, which enables the workers, the employees to negotiate, to put forward their demands, for the employers also to think back on how these can be met, whether that is suitable for the workplace, etc. While there is a mid person, which is where the government takes a role. Do you feel that this is the whole sort of in brief the history of it? So we have various kind of legislations. We have the Industrial Disputes Act. We have Payment of Wages. We have Minimum Wages Act. We have sexual harassment of women at the workplace, protection and prevention. We have Maternity Benefit Act. We have Contract Labor Acts. It's like I told you, there are about 30 or more legislations which are at play. Now, the most important legislation is something called the Industrial Disputes Act. What it does is, it creates an entire mechanism through which you can get your rights. So, the Industrial Disputes Act basically, on the principles of collective bargaining, set up a system where the employee can put forward their petitions. They can go in for conciliation, where there is a system where the reference is made. There is a conciliation procedure in place. If the conciliation does not work, then there is a reference made to the courts, etc. Just remember that along with it, there are some legislations which are meant to regulate, which are meant to place certain conditions in place. For example, you have something called the Standing Orders Act. What it does is, now for example, how do you know when you enter a workplace, what are my hours of work? How should I conduct myself? What are my designation? How should my appointment letters be given? All of this is put in place by under the Standing Orders Act. For example, what are the misconducts which I am not supposed to do at the workplace? How will I be treated if there are misconducts? What is the procedure in place to conduct it? All of this is in place. The Payment of Wages Act regulates, it came from a background where workers were not even getting their wages on time. Today, we take it for granted. They will get it on the 1st of the month or the 7th of the month, or they will get it in cash. They will get it in a particular manner where they are, where for certain there is a register which is maintained. So that all this act, payment of wages, put that kind of system into place so that the workers are not given where you are getting the payment for the work done at a particular time. There will be holidays specified, etc. Now, the Factories Act of 1948 was it was, now remember that all of this has happened during the time of our independence. So, even when we talk about 8 hours of work, we must thank Dr. Ambedkar for that, because of this is when he was the labor member in the Viceroy's Council. He was the first one in 34 to start putting forward a bill for 8 hours of work. The whole idea was that people would work for 8 hours People would rest for 8 hours, and the rest of the 8 hours was meant for the nation to do all those aspects for your own social needs, your political needs, your economic needs, whatever it is. All of this got regulated. Now, during COVID, okay, I want to just bring you back to the present. During COVID, you would have noticed huge groups of workers, people all on the street, and people were shocked. Hundreds and thousands of workers were just walking from Maharashtra to Bihar, from Kerala to Gujarat, from Gujarat to Hyderabad. People were dying on the way. Who were these people? If all of them, they are our working class, which was there. And who were they? They were mostly the unorganized people. Now, who are these unorganized people? When we talk about the working class is not a monolith. People have been divided into the organized sector, the unorganized sector. Then there are different types where you have regular workers, where you have casual workers, where you have badli workers, where you have temporary workers. All of these different types of workers are there. There are also self-employed people. Now, the question is that if all these legislations were existing, why were people hungry and on the road? If all these legislations were there for the workers. Friends, please remember and understand that our legislations are mainly for those working in the organized sector. And organized sector is not even 7% of the population. Most of the people working today are part of the unorganized sector. What is the organized sector? The organized sector, there are conditions of work, there is a system in place, there are legislations which will ensure that you get those benefits that you're supposed to get. While in the unorganized sector, while there is work and while some of the legislations are applicable to you, there are no structures in place to ensure that people get those benefits. So the people that you saw suffering and walking on the road are unfortunately our working class, which continues to be in the same situation. Now, what happened during COVID was that the multiple acts which I told you about, there are about 30 different legislations which are in play. The government, you all will remember that there was something called the farmers' struggle, and there was a legislation brought where farmers started protesting. Similar to that, during COVID, the government bought 4 codes. So what they have essentially done is the entire system of labor law has been dismantled. It is into and subsumed into 4 different codes. The four codes have been has come about in COVID, but for now it has been kept in a cold storage. We feel that it will come out in the times to come. It is simply a situation where there is an existing system in place, where the legislations are already there, the judgments are already there, people know where they are supposed to go, but these 4 codes have subsumed and taken away the existing machinery, and there will be something else in place. So what will be that something else will be? That there will be more of fixed term contract labor, there will be social security, but there will be the system where certain rights which were the hard won rights of people may not be have been sort of dismantled and may diluted. Okay. Now, sometimes there has been a question there was a question that was asked to me, that what about legal employment bonds which employees are made to sign in some organized sector. So just remember, friends, that when an employee is taken into the workplace, The employer may invest in you by way of training. Sometimes there are a long sort of educational programs which are conducted. Also, the kind of work which is given to you may require that replacement for it is difficult. In such situations, you will find that the employer makes people sign these so-called employment bonds. Now, people ask whether that is legal or whether that is a viable way in which whether the employer is doing the right thing. Now, remember that employment bonds are like any other contract. So, whatever is applicable to a contract will apply to these employment bonds. For example, if there has been coercion, if there has been a lot of force, or there is inequality, or it is not reasonable, then these things will not stand scrutiny. However, as per Section 74 of the Contract Act, if there is a contract and if there is a penalty to be paid, if there is a breach of that contract, then those are valid contracts. So but the penalty which is paid has also got to be reasonable. Secondly, that as per Section 27 of the Contract Act, it cannot restrict any trade or practice. So if the employment bond says that you can't go and work in XYZ company, those are not valid contracts. So the answer to this question is that these depend upon the kind of contracts which are signed and whether it is reasonable, or whether it is based on completely a contract between unequals where all kinds of restrictive conditions have been made out in the agreement. So most of the time these are not contracts which the employer also, depending upon the work situation, the employer also does not proceed further with it. Coming to the next part, the legislations, the mother of all these legislations, or where our rights are flowing from, is the Constitution. So what we have Article 14, we have 15, 16, which are all the equality clause. Article 19 is where we have the freedom of expression, the right to travel all over the country, the right to practice all the professions that we have. Now, what the courts have said, that if we have the right to practice whatever professions we want, we have the right to travel all over the country and practice all the professions we want, then we cannot also be facing discrimination at work. And that is how a lot of protections have been offered. We have also Article 43, which is talking about the living wages. We have what is a living wage? Living wage is Article 43 talks about the living wage. Living wage means that it is not just your food, your shelter. It also means that your family and your entire life has to have dignity, where you have time for leisure, where you have time for your own health. So it is not minimum wages. Minimum wages are the bare minimum that you're supposed to be paid, but what you're supposed to ultimately work towards is a living wage. Article 42 talks about just and humane conditions of work and maternity relief. Maternity relief, this is from where you get the Maternity Benefits Act. Maternity benefit is where an employee who is during childbirth is entitled to certain paid leave and monetary benefits. And now the benefits of paid leave is available for 6 months. It is also available for adoption. It is available if there is a medical termination of pregnancy and other conditions which are less than the 6 months, but the time period varies. But these are protections which are offered to the women employees. Article 43A talks about participation of workers in management, and this is something which has not been pushed enough, and instead they have brought about these codes. Article 23 is prohibition of forced labor. That is where we come to bonded labor, where there cannot be any forced activity of any kind, and that is for example, in India, you have what is called the begari, or you have a situation where the entire family there is a debt created and the entire family is made to work. So all those provisions come under the Bonded Labor Act. There are other legislations called the Provident Fund Act, where the employer and the employee both contribute for the situation which arises post the when your career ends, and this is a beneficial legislation which is available to you. You also have the employee state insurance scheme, which takes into consideration the health, the sickness, maternity, and even funeral benefits of the workers, where an entire scheme has been created, where there are ESIC hospitals for the workers, and there is an ESIC corporation. In fact, during COVID, many of these ESIC hospitals, which were meant for workers, were converted into COVID hospitals. So I would like to sort of uh, pause here in case there are any questions, and I can answer those.
There is one question over here. Brother worked for my handicapped younger brother worked for 26 years, did not got his retirement benefits.
So could you tell me where this person was working, and I would require something more from there. Any letters were written?
So the message is from Javed Sayed. So we require an appointment letter. You know, that appointment letter will give the description what was his scope of work when he was employed, what was his basic salary, and then we can take it further. Until and unless we don't have the appointment letter, we cannot give you the right uh, remedy what is available to you. But definitely there will be a remedy. So we need that before we go into details. So now,
There have been other questions that have come up,
yeah.
where people want to know that quite a few companies, they are putting this clause that if an employee leaves the company within 1 year, they are supposed to pay maybe 2 lakh rupees or 3 lakh rupees. How far is it legitimate?
So that's what I was just talking about. Those are the employment bonds which the employee is made to sign, and it's like any other contract. That's what if and according to Section 74 of the Contract Act, if there is a contract which such bonds are entered, and if there is a penalty that is there, then those are valid. But because the employer will have to give. There is an explanation. There should be an explanation and a reason for why these bonds are created. Are they doing something for you? Is there a training offered? Are they giving you any special inputs that are required? Because otherwise, one of the reasons why these bonds are signed is today, especially they notice among a population, say up to 25 to 30 years, that age group, is that they leave their employment very fast, say in a year, in a 2 3 years. So the employers also find it difficult to train people and then to replace people and to again put in those costs. But if there is nothing, if there is no such training which is given, no such special there is no special thing that makes it it should be reasonable, because what is the reason for them to sign this? So unless they are putting something into that, then it can be countered.
As you said that it's very enlightening that you mentioned that only 7% is of the organized sector. So if we think about it, the rest of the percentage, do you think that there is no regulation on those?
Yeah. So when people make this hype about the labor legislation, there are so many labor legislations. The truth of the matter is that they apply mostly only to the organized sector, where you go, there are certain fixed hours of work. But the mass of people, including women, in fact, the largest amount of women work in the unorganized sector. So what is this unorganized sector? It could be in construction, it could be in home-based work, it could be in domestic work. It could be now you have what is called gig work. You have platform-based work, which was not existing earlier. So I'll give you an example. We have something called the Interstate Migrant Act. I come to it because if that, in the presence, when that act exists, why were so many workers still on the road? Because they should have got some protection under it. And there is a system in place where the contractor has to make sure that there is housing, there is shelter, there is salary. They have to ensure that there is transport to go back. And all this labor, there is a machinery is not capable of ensuring that they do get their minimum wages, while the minimum wages act says that certain categories of workers should be able to pay the bare minimum. The minimum wages is the last baseline salary you can get, but there is no mechanism in place to ensure that there is uh, um, for the implementation of this act. One of the reasons for it is that I come back to what I was talking about, collective bargaining. If in an unequal relationship, if there isn't a unionization or there isn't a collection of people, how will they negotiate or go and ask the employer, look, you're supposed to give me health benefits, or look, you're supposed to give me minimum wages? They are unable to do it. And the casualization and unorganization of labor has led to a complete deterioration where the organized sector itself is getting dismantled. The government companies are closing, so that avenues are closed, and the private sector has further gone in for contract labor. So contract labor, while the Contract Labor Act exists, while the contract labor is supposed to be provided with Provident Fund, there is all kinds of provisions are there. Health benefits should be given, their protection should be taken care of, their safety has to be regulated. How do you ensure it when the workers are not able to ask? If the workers go back and ask, why am I not getting it? There is hire and fire, so you will get thrown out of work. So what has happened is the contractualization has broken the structure of the implementation of these acts.
So basically, if you see in a nutshell, other than the 7% that we are talking about, the organized sector, the other 93% are the vulnerable class. They come under that.
Under the Industrial Disputes Act, everybody who does not come in the definition of a workman, there is a definition of a workman given in the Act. If you don't come in the definition, then those rights are not available to you. What is available to you is then a contract between the employer and the employee. So the employer is also concerned that they don't lose the good employees, or they ultimately have to run the businesses, and a business cannot run without the cooperation of the employer and employee. So in that sense, they're supposed to follow, give provident fund. They're supposed to give bonus. They're supposed to have an ESIC regime in place. Or they are supposed to follow leave, how the leaves will be given, what kind of sickness benefits will be given. So all that is in place, but that happens. But for the wide portion of those who are in the unorganized sector, that depends on the mercy of the employer or the contractor.
Some time back I had filed a PIL for shortage of staff in all the government departments across Maharashtra. And there were about 37 such departments, including the High Court, the Notary, and all these people. And it is very surprising that, despite of having so many vacancies, still the vacancies are not being filled, and the government is depending majorly on contractual laborers, wherein these laborers, the companies don't have to pay them pension or other benefits and all that thing. So it becomes very easy for them that get the work done and just that's it. So there is no basic commitment behind it.
Yes. It's a it's a deliberate dismantling of the labor law regime,
Right.
which is there. And that is going to be more and more, you will witness it, because in the new codes which are coming, which are already there, when they will implement it, I'm sure in the next some months to come, it will happen. They speak about fixed term contracts. So everybody will be on fixed term contracts. You may get your wages, but what we saw, to build a life or to build a career where you have a long years of work, post which you will be available, some pension will be available. All those things it will be gradually, and because they're deliberately not filling vacancies, because then that enables contractualization.
Right.
In fact, government PSUs and government companies also, large number private employers are, most of their work is being done by contract labor. Whether you see it in airports,
Yes.
you will see it everywhere. And each aspect of your work is being controlled by the contract labor.
Even in the military, now what we have seen that they will only for 3 years, they will be employed and then
absolutely.
Yeah.
This is what it is.
In fact, it is
you gave the right example actually, because this will give a mental picture of what to expect. Because you will, so even if you die somewhere, that is the end of it. I mean, you're not entitled to anything. You can work and you can go.
So there is one more question put up by Pushpa Binde. I think my provident fund received by me after retirement is less. I have repeatedly shown this to education department, but they are not responding. My college management showed me a retired person in 2006, 2007 and settled my claim. I was very much in service till 2018. The claim has been settled between my college and education department. So now what the remedies available to her?
Yeah, difficult to follow. But
now, the crux of the matter is provident fund received is less than what she has expected or what as per the norms. So suppose she was supposed to receive 10 lakhs, she might have received 5 lakh rupees.
Possible that the PF functions that the contribution of the worker goes, and the equal contribution of the employer has to be deposited with the Provident Fund office. So it depends on whether many of the workplaces now, in fact, I've just recently heard that many of them are cutting the employees' Provident Fund, but not depositing theirs, and they're not depositing the employers at all.
Their share also. So they are getting the benefit of cut from the employer's fund, plus what they are supposed to pay. Yes. So they are also saving.
Yes, and what they are doing is that when you are nearing your retirement, they raise all kinds of privileges. Yeah, that oh, you've grown too old, you are not able to work, or they will put unreasonable targets which you will not be able to, and maybe pressurize you to just leave and go. So sometimes what happens in the follow up, and plus all the data and the papers are available with the employer, what it will actually require is to go personally to the Provident Fund office with the papers, because the papers, you will have all your papers in place, at least with what is received, and then think of what will be the legal remedy available. But first, you will have to go to the Provident Fund office, and that this is the situation. Also, it depends on how many years have gone by, what is the documentation available.
So, in fact, I am fighting two labor cases. One is against the BMC. He was born in 1972, but by mistake in the service record, it was written as 1966. So he will have to retire 6 years early. So that is one case we are fighting. And there is one case of Provident Fund. The employer deducted the money. Now, the employer is not a service provider, but the scheme in which the money was deposited, they have not credited to his account. So we have filed the case in the consumer court, making that service provider, that Provident Fund, and the employer. Now the employer will come with a record that I have deposited my share of money into the whatever the scheme was there or into the bank. If public provident fund, they are not able to get the record, then how it is good. So it's a little complicated matter. But if you have records like my client has, then we can show it to them that this amount was deducted from my salary, not received the credit yet. So now he's fighting for the last 10 years. He has come to me recently. Now, everything when we calculate in a simple interest, the amount goes to around 35 to 40 lakh rupees. So whenever you are employed, you should have your documentation with you so that in case if there is a dispute, you have the uh, available documents to fight your case.
Also, as you said, that it would be more advisable for the employee to visit the Provident Fund office with the registered code number, or
Yeah.
so that you may know that whether the company is depositing the amount that is being deducted from your salary. So you will know somehow that things are on the right track, or something that needs to be done about it.
This is the one department where you go, they have a
Yes.
big godown and the piles of papers, it is not digitalized.
Yes.
The thing is available on the computer. So they will tell you, you search and give it to us. So it is something which the government has to wake up and do something about it. When I went with that person to that particular office, they tell me that there are hundreds and crores of rupees lying idle because people don't have the records with them to claim this money. So that money is lying idle. So we should, take up this as a challenge, file some PIL in the Supreme Court or High Court, and get that money which is blocked in the Public Provident Fund released to the beneficiaries who are supposed to be there, or use it in a putting up a hospital or college or universities.
What I would request, Mini, is to enlighten our viewers that when you approach the Provident Fund office, what things to look out for, so that uh, they may keep themselves updated so that such things don't happen.
No, it depends upon case to case. So normally the provident fund is taken care of by the employer, and the entire system, they have a staff in place who take care of that. And now there is also there is some amount of computerization also, but the sad part is that with an employee, what happens is when they leave, they don't have access to a lot of, or it depends upon how empowered they feel to ask that about their this. So really, for the first step is to look what are the documents available. And I think in where this question has been asked, it seems as if a lot of years have gone by, and so it would depend on the facts of the case as to how to pursue it. But definitely going to the PF department and saying that these are the things, can you make available the data to me? Only then can we say that which. And now, like what was just said, more and more what I'm finding is that while because of the way labor legislations have slowly with hire and fire, and what is happening is that other remedies have to be used in order, even in labor matters. For example, in certain labor matters, if you don't come in the category of a workman, where is your there is nothing available to you. Then people have to see whether they can use the civil law, whether they can use the criminal law. So in that sense, each case becomes a thing by itself, while the labor laws, the 30 or so what I told you about, they do offer, for example, I will tell you that if it is, say, contract labor act, it will say that what is the contract labor, what is the contract worker supposed to get, how to maintain a muster, how they should have documentation. But today I'll give you an example. If the employer chooses to just put 4 people onto the register and the rest 100 are working without being on the register, the only way out is for the whole machinery of the labor department to go and do these inspections. So unless they go and do these inspections, how will that poor worker be able to see? The unemployment situation is so bad that you're just happy that at least you have that bare minimum. How if you ask the contractor, please put me on the register, the only way you're going to get all this is if you can be on the register. Only then your benefits will kick in. Only then you will get your chutti. Only then you will get your sick leave. Otherwise, you're not going to get it. And for example, what will happen if there is an accident at the workplace? So your employees, so all these compensations, etc., also are linked to, they will not show you on the records at all. And to do that is where I come back, is what collective bargaining was about, which is that you have to be in a group to be able to go to your contractor or employer and say, look, please, this is the law. Can you please do this? Because there is still some amount of power in going as a collective rather than as an individual.
So we come back to the Datta Samant period.
No.
And you have a union leader and
no, that's not what I meant. There are, without, otherwise, unless there is a collective, all of this is going to remain on paper. And we will all be part of that 97% if even these things will not be able to work. Because once, even in the government sector, if they don't fill in the vacancies and they just make it into contract labor, gradually people will grow old and there will be only contract labor. And there will be only few people at the top level.
So the first thing is that you should have an appointment letter describing your scope of work, the job. Now I have seen many labor cases, when they go to the labor case, the management comes and says that he is not a labor, he is a manager. And 10 people were reporting to him and he was making the report, so he doesn't come into that. So how you deal with that type of cases?
So, as I said, under the Industrial Dispute Act, there are two definitions which are very important. It's that of the workman to the industry. So if you don't come into both these categories, if the workplace is not coming under the category of the industry, or if you don't come in the definition of the workman, you have no protection available to you. I'm not saying you don't have any protection. You have to choose other things to make it happen, but not within the labor setup. But the courts have, remember that in labor jurisprudence, most of the law that came about is judge-made laws. So you have a very creative application of many of the laws. One of the most litigated aspect is on this issue of whether I am a workman or no. So the courts have held that it is not your designation. Tomorrow you will be given any designation. That designation is not, as an employee, I have no right to decide what my designation is going to be. The employer will call me super manager, or he will call me director, or he will call me CEO. But he will, it doesn't matter what he calls you. It depends on what is the nature of work that you're doing. Who is supervising you? How do you do that work? So the employer will try to, if he or she is trying to put you out of the category of the workmen, the courts are not going to look at it. The designation does not matter.
Normally, I have seen this happens in the construction industry. Then he is appointed as a supervisor. Then he will be said that he is a site manager, but he is doing all the work of a labor.
Yes.
But the way the papers are put up, that he doesn't come into the labor category. So you have to be right from the beginning little careful. We don't want you to fight with your employer, but you have to use your wisdom so that you are there in the job also, and then you are performing also. It should not happen that you take this help of this laws and you don't perform and you expect that company to pay you. So it has to be a win-win situation for the employee also and for the employer also.
The main thing, the courts, if the courts don't go by, they also see these cases every day. So they know that even if you're called whatever it is, what is the actual work that you're going, and for that you will have to lead evidence. You will have to go through the trial just like any other case, because it's like any other litigation.
And it takes time. Especially the labor courts which I see in Bandra, it is not that you get the justice within 1 or 2 years. It's on dragging for many reasons. We cannot blame only the court and the judges. So everything has to be changed. So, and the change you can do it is on 20th May in Mumbai by using this finger. Not promoting any party, but you should use your finger, come out, vote for a right candidate that is going to stand for you. So with this, we come to the conclusion. Any concluding comment from both of you?
Thank you for listening.
I think so. There's a lot of things that have been enlightened by many of you, and it is really very good for our viewers. If in case there is any question that people want to know, they can mail us or WhatsApp. We will try to answer them.
So I hope you all like this video channel, and if that is the case, that you have got some insight, you can share this video with your friends and contacts, and we can build a very big community. And we will talk only about the constitutional rights which are given to us by the Constitution of India, and we can empower ourselves. So see you again in the same channel with new topic and with a great speaker. Till then, be safe and remain healthy. Thank you.